claimants are more clearly identified as interested individuals. There's no need to show a particularized or a personal injury in this. So this would be any group that wants to stand up and say that's our heritage, or this is something celebrating the life of individuals or whatever, then they could do so. It also sets forth something that cities and counties and those public entities should like, and that gives a process. And the process is that if there is no litigation and a community wants to do relocate or do away with a monument or statuary, then that process would be publicized in the legal organ for 90 days and take testimony and hear comments, and then they can decide. If a third party comes forward, whether it be a historical group or somebody else, then they can come forward, and then that city, county, or whoever, they can offer that monument to who they seem to be in their best interest. Now, I've had discussions with my friends at ACCG, and they have concerns, a little bit of concerns, that, well, who are we going to give it to? Well, quite frankly, local officials have to make a judgment call. If it's the difference in an individual for some other purpose or a historical group, then that's kind of simple in my mind who they would choose. That monument would then be moved. The entity of city, county, whoever, if they disassemble it, they can move it to that person's property, and that person or group would have to put the monument back together. Second part, if there is litigation, and once it goes through injunctive relief and the merits of the case is heard, if the judge rules against, a judge of competent jurisdiction, if they rule against, then that sets off another 90-day prospect. So then that local government can then go through the same 90-day process and award that statuary to somebody else. That's the simplified version. Be glad to stand for questions.
Thank you, Chairman. Oh, you actually have a couple of questions. First question is Mike 9, Representative Burnell.
Thank you, Mr. Chairman. So based on what you were saying, we'll have this law, but then the cities and the counties will take the brunt of the complaints and everything, because they'll be making a decision. Is that, am I reading that correctly? Because you kept saying the cities and the counties would make decisions.
If they make the decision that they want to do away with a monument, for whatever the reason, you know, this sets forth a process, the legal process, and it sets forth injunctive relief. But depending on how that goes, then they can offer it up. If there's no litigation, then there's also a pathway that they can offer that statue up. They just take a 90-day, run it in the paper, run it in the legal organ for 90, then run a 90-day schedule for comments, public comments. So it's a way of doing away with the statuary that would be fair and equitable.
Okay. Did a particular group bring this to you?
UDC, the Daughters of the American Revolution, and the Sons of Confederate Veterans.
Okay, thank you.
All right, next is Representative Oliver.
Thank you, Mr. Chairman, and thank you, Chairman Powell, for chatting with me about this bill. Decatur, City of Decatur removed a monument with an approved court order, and the Supreme Court upheld that decision from the City of Decatur. I think Glenn County also removed a monument, and the Supreme Court approved that action by City of Brunswick. Am I correct?
You are correct.
Are there any other cities or counties that have reached the Georgia Supreme Court on this issue?
I really don't know. I know that there was a case, and I'm not sure what happened to it down, I think Henry County maybe, and I'm not sure.
My guess is that there's not another, that these two Supreme Court cases, which is confirmed authority for the city county to act, I'm trying to figure out why we need to change the law at this point that further restricts City of Decatur, City of Stonecrest, City of Atlanta, the three cities I represent, or DeKalb County, from taking any other action that the Supreme Court has said they may.
I think it gives them another pathway. to end any acrimony. City of Decatur took down the monolith that was over in front of the courthouse. It's been in storage somewhere ever since. Nobody knows where it is, what the condition is, but when you move statuary, there's a possibility it's going to be damaged or destroyed, and this would give the county room to free up their valuable space and resources just to get rid of it, give it to somebody else.
I know a little bit about the City of Decatur's advertisement and solicitation and public discussions about who might want it and who didn't, and I thought it was fairly well publicized locally. To what extent does your bill change the Georgia Supreme Court's decision on standing? And if ACC or GMA want to have a position in
ACCG is asked to speak, so.
Okay, good.
Yeah.
Have both, I'm sorry, Mr. Chairman, both them or only GMA?
I only have ACCG on here.
Okay. The logistics of a registry, I'm trying to think what registry exists now. We have the historic monuments. For the City of Decatur, we had a historic Georgia State Archives monument. Are you trying to create the registry for the purpose of primarily the private monuments?
I think what we're trying to do is there is no registry about where monuments are. And this registry would be under the Department of Community Affairs. Let them just create a very simple registry.
Why do we need it?
I think that we need that for no other reason than for the tourist value. I know that people find it hard to believe, but we do have tourists that come by and they want to see historical sites and things like that. And of course, Community Affairs isn't going to go out and hire somebody to start going around the state. They will generally be reported between historical societies and the city councils and the county commissions. They can forward that information voluntarily.
I'm trying to figure out, and this will be my last question, Mr. Chairman. Thank you for indulging me. Your provision on page 5, beginning of line 107, I'm trying to figure out what's real benefit of having legal notices we're about to do something when there's no other equivalent statutory requirement that a city or county do a publication that says we're about to build a park on top of we're about to build a switch over top of the 85. I'm trying to figure out why this is necessary as opposed to other important actions that counties or cities take.
Well, this is a process to try to put a lot of the acrimony at arm's length, to stop some of that. If a city or a county makes it be known that we don't want a statue in our community or a monument, that if there's no litigation that's involved, then they can offer that up. There's always historical groups that may want to take that monument and move it to their locations. You know, I've been an advocate for years in a lot of the communities that don't want monuments of a certain type, that maybe some of the historical groups need to volunteer to say, we'll take them off your hands and go out somewhere and do a monument park dedicated to whatever the group it may be.
Thank you, Mr. Chair.
All right, next on the list is Representative Sanchez.
Thank you, Mr. Chair. So it is a common practice, as a form of protest to, show people's disregard, or when they disagree with something, to, issues with monuments that they have. Is this attempting to infringe upon people's right to protest and free speech when they disagree with some sort of monument?
I would say just the opposite. This is a methodology for statuary to be removed, to be relocated, or whatever, that would stop a lot of the disagreement in the political rhetoric.
Okay. The further question, would it help with that if it makes the process harder and more difficult for it to be removed?
I'm one that believes, as a student of history, I've been up here enough times and I've lived through flag changes and everything else. And generally, a lot of that I find to no good end, creates acrimony among people that could be simply solved by using some common sense. If you're a community that doesn't want a statue, then give the statue up. Offer it to a third party that might respect that statuary. Do it that way. I mean, it's time that we quit living in the past and start moving toward the future. It's like a monuments that are, I've always said that a lot of people always tried to portray these like the Confederate monuments, that these Confederate monuments were there to stem an uprising and to promote an uprising in the future. Most of them I have found, they're there to commemorate the dead, those who gave their lives. And at the end of the day, to honor the dead and whatever their reason was, they're dead. Honor that cause.
Thank you.
All right. Let's see. Representative Williams, Representative Burnell, we'll give you another chance after everybody has a chance to get the first question. Okay.
Thank you. Thank you, Mr. Chairman. So I'm actually, I think this is the question that Representative Oliver was asking. My question is, and perhaps this is going to be answered, if you pass this bill, does this mean you no longer have the process of litigation that took these issues to the Supreme Court? Does this change that
Does not
process or do
change
away?
it.
What? Yeah.
Doesn't change the litigant process. It just adds another wheel to it, that if they want to avoid litigation, offer it up. If there is litigation, then after, if the ruling of the court goes against the complainant, then it goes again, well, we're going to give you this statue. Do you want it? If not, we don't want to keep it tied up in our storage buildings or wherever it is.
I just wonder if I'm just trying to figure out if it muddies the waters of the ability of someone to bring a lawsuit. That's my question. Thank you.
All right. And I'll recognize Representative Burnell one more time for one last question.
Thank you, Mr. Chairman. Two things. One, when we say that we have to put in a legal organ, I know that just like for my county, most people don't even know what a legal organ is, and they don't really even see it because those newspapers are no longer they're not available. So to put it in there, if you're trying to keep something, that's a good place to hide it because nobody will see it. The other part is, and this is just because I've been on this committee with you for so long, and you like to come and tell us about storage and containers and where things could go. So if nobody takes it, or you're saying that, they could just move it and just put it someplace, but that's assuming that the county or the city has a place for it to go.
And I'm sorry, but I missed the point.
I think that that's not fair to tell them that they could store it and say they don't have it, and then they have to pay for a storage room.
The storage would be based on if it goes through the court proceedings, depending on the rendition of the court, whether it can be moved or otherwise. This is a way that they can get rid of it once and for all. The part that you mentioned about the legal organ, I'm not going to necessarily disagree, but the legal organ is still, under Georgia law, considered the way of official notification. And I would be, if you'd like to amend it to say legal organ or county website, or county website, I have no problem with that.
Okay, thank you.
Thank you.
Chairman Powell, I've got one just friendly question here. I noticed that you added the term "or privately" in this bill. What happens if you're a private landowner and you have one of these on your property, and obviously you don't want it? You don't want it anymore.
If it's on private property.
Yeah.
The bigger issue that we have, you have some private organizations that own the statuary that's on public property. In the aftermath of the Civil War, a lot of the widows and the ladies that formed the UDC, they took up subscriptions. They raised money to build these monuments you see all over that are so proficient around courthouses to honor their dead. they actually own the monument.
Okay, so I guess when I'd like to talk with you offline, just to make sure that it's clear that it's or privately owned monument that is on public property, just to make sure that you don't somehow ensnare somebody in that may have a private monument, I don't know, for whatever reason, on their own private property.
Private monuments I know on public property would
Yeah.
be those that were put up in memorial to
Okay.
the dead.
Well, Chairman Powell, I don't have any other questions. I think we're going to do this hearing only for the moment, and then we will get with Chairman Anderson over here, and we'll figure out
Thank you
how to
so
move
much,
forward.
Mr.
Thank you.
Chairman.
Actually, you know, I take it back. Now, looking at the sheet, I've got 2 speakers on this bill. Thank you. That's okay. It was weird. So first, we're going to call Ms. Day with ACCG.
Thank you, Chairman and committee members. I'd like to thank the sponsor. As he mentioned previously, we've been in talks, and I respect his well-intentioned bill, but we do have just a few concerns from the county's perspective. First, the bill doesn't lay out a process for if multiple third parties are interested in taking the monument. Now, there is a provision in giving preference to those who agree to keep the monument within its jurisdiction, but what if there are multiple groups who all have this same agreement? We feel that this may put the county in a tough spot and open them up to litigation and having to choose which party gets that if they all meet that preference provision. Secondly, the county does bear the cost of moving the monument, as previously mentioned. And I don't have any specific Georgia numbers on this, but I know a few years ago New Orleans removed 4 monuments, and that totaled to around $2 million in cost of removal. And so we just do not feel like this is a fair financial burden onto the counties. And I truly hope to continue speaking with the sponsor on the bill. I appreciate y'all's time, and I'm happy to hold for questions.
I don't see any questions. So thank you, Ms. Day. I appreciate it.
Thank you. Thank you, committee.
I'm trying my best here. I'm gonna say, Mr. Schneider. No. Nope. There you are. Oh, okay. And we got to work on your handwriting. This is rough.
That's what a doctor or a lawyer has no handwriting. Members of the committee, I'm Les Schneider. I'm not representing anybody in particular on this. Obviously, I've worked on some of the wording on this, but I just want to point out that Representative Oliver is right. It does address the issue that the Supreme Court made the decision they made, and this does change and provides for injunctive relief. It does provide for standing that the courts have all addressed. The point that I would like to make to you today is some of the issue of history that Representative Powell talked about. Let's say we have a Holocaust memorial. Let's say we have a monument of Martin Luther King. Let's say there's a Confederate monument that's there. Unfortunately, with the political winds, and let's say there's a Vietnam monument, you know, you may have people stand up and say, well, let's not have a Vietnam monument because that was just a war of losers, or let's not have the Holocaust because it really didn't exist, or Martin Luther King wasn't as good a civil rights leader as everybody thought he was, and things like that. What this bill does is basically says, look, once the process goes through as to whether injunctive relief is granted or whether the merits of the decision are made, the question becomes, do we just simply let the political winds of what history are we going to deny today and we're going to eliminate? Rather, we have a process where if the local government or the agency wants something removed, should there be a clear path that if somebody else wants to continue to have that monument displayed, we have a very easy way to do it. It could be done with litigation, or it could be done without litigation. And that's in essence of what this bill does. It's not taking favorites. You know, I may not be an advocate of a particular monument, but I probably wouldn't spend so much time fighting for its removal. Other people will. But all this does is basically say, look, very simply, if the local government is going to move it anyway, and they ultimately move it, there's a cost to that. In this particular case, the cost that they are going to absorb is moving it to somewhere else of similar prominence, either in the county as a preference or in the state of Georgia if somebody else wants to do it. I've been to New Orleans. I've seen statues removed, but I've also seen a monument park constructed where you have different kinds of monuments all the way through, and it is a big tourist attraction. It is something that records history and describes it. And the question is, are we going to simply say, well, a particular statue we don't want, so therefore we should be able just to deny whatever history occurred in conjunction with it? I think a local government certainly has the right to decide they're going to remove something. The question is, can we place it somewhere else so that we, in essence, don't just deny the history? I think that's the genesis behind this bill. So that's my bicentennial minute on this. I certainly will stand for any questions.
Well, you have a question, so Representative Oliver.
Is the state of Georgia, the Georgia Building Authority, covered by this statute? If we wanted to take down, some group of we, not me, some group of we wanted to take down the statute of the forester, General Forest wanted to take down a Confederate monument on, right out in front of this, do we have to provide?
Just as when you move Tom Watson across the street, it would be the same type of issue. Now, in his case, they just moved it across the street, so there would be another place of prominence. But let's say, as you said, they wanted to remove a statute, but they didn't want to put it anywhere else.
So the state of Georgia would be covered by this statute in addition to the city of Decatur and DeKalb County?
I'm looking at the definition of agency in the very beginning, and it says any state or local governmental entity. So I assume that would be included. That's right.
Stone Mountain Authority would be covered by this for sure.
Yes, I believe it
And
would.
so Stone Mountain Authority already it moved some flags recently, and they have other plans for various changes. They would be subject to this added administrative burden and added litigation invitation. It's set forth in this statute.
Or if they just wanted to move it and someone was willing to take it, then there would be no litigation. But you're right, there would be something that would be filed, but something could be filed today because that definition has not changed.
Thank you.
Seeing no other questions, thank you. I
Thank you.
appreciate it. All right, that concludes all our speakers on this bill, and like I said, this will be a hearing only. So, Chairman Powell, please do your. Thank you. All right, the next meeting on the agenda, Chairman Anderson, do you want to present from here, or? Oh, I have absolutely no problem. That's what it, Chairman Anderson will be presenting HB 521. Chairman Anderson, your mic is hot.
Okay, thank you, Mr. Chairman, and I appreciate you allowing me to not have to change seats here for a moment. House Bill 521 is a relatively simple bill. It's very narrowly tailored. We've spent a lot of time, or I have this year, working on follow-up language to bills that we've passed in the past. This relates to de-annexation and applies to a very specific scenario. Just to kind of read, starting line 23 on the bill, excuse me, if the county is the owner of all parcels proposed for de-annexation and the governing authority of the county consents, the governing authority of the municipal corporation shall approve such de-annexation within 90 days of the date of the filing. And then, of course, you can read the rest of that long run-on sentence there. But basically what we're doing is we're putting a 90-day time frame for this exact scenario where a county is wishing to de-annex county property from a municipality. The law, as it was passed before, does not put any kind of time frame, and I know there's been at least one situation where that process was delayed and could have potentially been delayed indefinitely because the law does not specify a specific time frame. So this is just a kind of a follow-up to a bill that the chairman carried a couple of years ago to kind of work on our de-annexation process and a companion to what I was doing on annexation disputes. So with that, Mr. Chairman, I'll answer any questions.
Okay, do we have any questions? Seeing none, I just want to make a general comment. I appreciate you bringing this, and I think this is just one more clarification in the law that's going to help local government work together in a coordinated fashion, which is best for all the citizens. And actually, we do have one, Representative Burnell.
Thank you, Mr. Chair. I just have one question. What is an example of property that's owned by the county? Because it also, I guess, because it says for the welfare of the residents and property owners. So what would be an example of something they would de-annex?
No, very, very good question, and I think we have someone sign up to speak to that, a specific situation to that, but just in general, let's say an athletic complex that is within the city limits, but the county wants to do some expansion. It would be a more streamlined process for them if they were able to deal with their own codes and regulations rather than having to work through two layers that way. So there may be some interest there. There's really limited, if any, expense or that sort of thing to the city because counties don't pay property tax anyway or ad valorem tax within the city. So.
Okay, we have one person signed up to speak, Chair Carlotta Harrell from Henry County. Which, that's what's that, Chair? Yeah, a chairwoman. Yeah. Thank you for being here with us today.
Yes, absolutely. Thank you. I'd like to, if you don't mind, Mr. Chairman and committee, to ask my county manager, Sharon Matthews, my deputy county manager, Kevin Johnson, and Ashley, you have some packets that we'd like to share with you all, if she could pass the packets out to you all with regards to a situation that we're currently going through right now in Henry County. My name is, I'm the chairwoman of Henry County, and basically, I'd like to thank Chairman Anderson for carrying this legislation. Thank you for your time today as we discuss an important topic to Henry County. House Bill 521 is a product of several months of conversation regarding a de-annexation of county-owned property that was submitted to the city of McDonough but remains in limbo. The de-annexation, as outlined in your packet, was for 10 parcels of county-owned property and followed the requirements outlined in de-annexation. For example, it would not create an island and the parcels are continuous. We understand that the county administration building has to remain in the county seat. However, the submission still adheres to the intent of the law. Based on updated capital project timelines, Henry County will resubmit an updated de-annexation until such time that the administration offices are moved to the county square, as the intent would when originally submitted. The de-annexation was submitted to the city in April of 2024. And as of today, after multiple attempts to mediate, has not been submitted to the Georgia Department of Community Affairs. There are several large capital projects ongoing on these parcels, including a multi-million-dollar aquatic center, a new E911 center, and a training facility for our fire rescue team. The county's inability to review and inspect these facilities for building and permitting purposes causes impacts and delays to these projects and has the potential to hinder significant progress needed to maintain and improve the county level of service to the citizens of Henry County. One other project that's being upheld is that we have a public-private partnership with an organization called Mighty Heroes. County land was going to be utilized for tiny homes for homeless veterans. And so this has no impact on the city of McDonough. The de-annexation process, because there's really no timeline like in annexation, then it's just set, and it's held our projects up. And so, you know, we're trying to, you know, get our projects off the ground. We've got a lot of things in the hopper, and it has no impact on citizens, on safety, or anything else. It's county property. And so we just want to be able to move forward with our projects.
With that, I'll open up for questions. I actually have a couple questions for you, if you wouldn't mind.
Yes.
Does the county have to pay taxes to the city on that property?
No.
No? Okay. My other question to you is, when you, how would you describe the relationship between the county and the city of McDonough? You know what? That answer's enough. Thank you. I think we'll take that as the answer. I actually.
So let me say this. We try to work with all of our municipalities. We just don't understand the hesitation on property that belongs to the county, even though it's in the city limits, of why we can't de-annex to the other property that's in the county part. So I don't have an understanding of why not.
So just so you know, I've worked pretty hard to get the de-annexation law even in code, and one of the personal property rights is one of the underlying issues of why I worked so hard to get this in, because I would agree with you. I think it's a personal property right of a homeowner that doesn't want to be in an area that feels like they don't need certain things. I have to tell you, I'm a little disappointed in myself that I missed the timeline piece of this, but I'm glad we're getting it clarified in this piece. And thank you for highlighting some of the issues that we're seeing. We always assume that local government's going to work on the up and up, but I mean, sometimes that just doesn't happen. So,
right, and we've had some situations even in the city of Stockbridge. They put a referendum on the ballot, and which barely passed, but it annexed a bunch of people into the city of Stockbridge. Now we're getting tons of applications from residents that didn't want the annexation that are de-annexing. We had a whole subdivision that de-annexed from the city of Stockbridge because they didn't want to be in the city limits. And so the de-annexation is really an opportunity for property owners to be able to make that decision, whether you want to be in the city limits or whether you want to be in the county. So thank you.
Well, thank you. And I didn't mean to hijack your bill with those questions, Mr. Chairman. Let me know how that process works. I'd like to stay involved in that.
Okay.
This is kind of one of my personal issues. So with that, I see no more questions. And thank you all very much for being here today. I'll go ahead and open the floor for motions. All right, I got a motion and a second. With that, all in favor? Aye. Any opposed? Thank you. Mr. Chairman, you go on to full committee. Congratulations. Thank you. Mr. Majority Leader, I know you're here to present a bill. Did you want to present it from up here, or would you rather do it from the podium? It's at your pleasure, Mr. There, let me.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee, subcommittee. For you today, a proposed committee substitute to HB 416 LC 443107S. So several years ago, when I served as a floor leader for Governor Nathan Deal, I carried a bill to assist with the redevelopment of downtown Atlanta that created what was called an enterprise zone. So this enterprise zone would allow for particularized tax treatment to address areas where there had been critical deficiencies for extended periods of time, decades, and there was a need for redevelopment and focus in Atlanta. That is where it has been utilized. Now, there was some litigation around this that delayed implementation for several years, and what I brought here today is an effort to address the delay that occurred, so that the bonds that were and would be issued, that the timeline would be consistent with the legislation timeline that was anticipated when it was originally brought, and that also would put into code specific aspects of ensuring that this meets with the original anticipation, which is those who are operating businesses within the zones, that it would apply only to them, and that it can't be gamed by individuals who may claim a presence within the zone but in fact are operating outside of the zone. So that's an attempt to succinctly explain. This is truly, to my mind, recalling the bill that I originally carried. This is an effort to make sure that we stick to the original legislative intent, how it was explained and why it passed the General Assembly several years ago, and just stick to the timeline that we hoped and expected then, but due to unforeseen circumstances was delayed at some point. Now, the original bill that I introduced, after I introduced it, I met with the Department of Revenue, and the Department of Revenue had some questions, and as a result, I have worked on this committee substitute, which now addresses Department of Revenue's concerns. So I'm happy to stand for any questions. And also, Attorney Robert Highsmith is here, and Mr. Chairman, at the appropriate time, I'd ask for him to be available for questions if we get into some of the additional specifics where he can give clarity.
Absolutely. Mr. Leader, you have two questions. The first would be Representative Sanchez.
Thank you, Mr. Chair, and thank you, Mr. Leader, for bringing this bill forward.
Yes, sir.
So, question on this. You said this bill was brought in back during Nathan Deal's term, you said?
Yes,
correct?
sir.
Has this, I know there was a delay, but has any of these projects been able to provide affordable housing in the downtown area up to this point with the current process that you have now?
Yes, sir.
Okay. And my second or third question, if I may, Chair, is would these changes help ease the process to have even more affordable housing, would you say?
Well, it's going to provide additional housing, which is going to be affordable, is my understanding. Obviously, the investment also in the downtown area, well, there are many investments being made in the downtown area to allow for affordable housing.
Okay, great. And final question, what is when it's affordable housing, what is the usual AMI for that?
I do not know specifics, sir, but if we can work together offline, I can connect you with people who can get you those answers.
Awesome. Thank you so much.
Yes, sir.
Representative Burnell.
Thank you, Mr. Chairman. Is this only for the city of Atlanta?
So the obviously general legislation would apply and be applicable statewide, but it was tailored with a specific focus on Atlanta when it was originally introduced because of a specific need in Atlanta and in partnership at the time with the city of Atlanta. But obviously it being general law, it's general law.
Okay, because I think we have an enterprise zone in Clayton County. That's what I was asking. Thank you.
Representative Oliver.
I'm happy for Mr. Highsmith if you prefer to answer this question, but I'm sure you can. It sounds to me like this bill comes out of litigation in relation to a project in Atlanta.
So
And the purpose of your bill is to correct whatever gaps or issues was gained from that litigation. Am I right or wrong about that?
So my concept of this is it was anticipated that bonds would be available and issued based upon a certain timeline with approval at the time. Due to the political process around that approval and then subsequent litigation, there was a delay. But this is not in response to or to address any litigation. It's just what resulted from that was a several-year delay that wasn't anticipated when this was originally brought.
And no one opposes this as far as you know?
No one has come to me in opposition to it. Department of Revenue just had questions as to what the specific objective was, and by myself and Mr. Highsmith meeting with them, going through it specifically, we've been able to work up this substitute, which addresses those concerns.
Thank you.
Yes, ma'am.
All right, I see no other questions. I'll open the floor for motion. All right, we got a motion to pass with a second. All right, all those in favor say aye.
Aye.
All those opposed? Hearing none opposed. Mr. Leader, congratulations. You move on to full committee.
Thank you, Chairman and committee.
With that, we have no other, I know we have a couple other on the agenda, but we're going to push them to a later date. So we have no more on the agenda. Thank you all very much, and we are adjourned.